Your Honor, Mohammed on behalf of the people, P86771.
No, it's not. You have work. So
Yeah,
you're on Friday.
Are you representing at the desk, representing yourself?
Judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding.
The moment this hearing begins, you can already feel the tension rising. Judge Oakley is not the kind of man who plays games in his courtroom, and the sovereign citizen before him, Frank Michaud Jr., is about to find that out the hard way. From the first few seconds, Frank tries to pull the same tired, "I'm the beneficiary of my own estate" nonsense that these pseudo-legal gurus love to recite. But Oakley doesn't flinch. His courtroom authority fills the room like a thunderstorm about to strike. You can sense the collective eye roll of everyone present as Frank begins his word salad of confusion. And if you've ever seen Judge Oakley before, you already know this is going to be less of a legal debate and more of a one-man demolition show.
Objections all the time, overrule objections, they are preserved on the record. If he has...
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All
I?
right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need.
The tension hits boiling point when Frank refuses to sit at the defendant's table. It's a classic sovereign citizen move. Pretend the courtroom isn't real by standing somewhere else. But Oakley doesn't buy it for a second. His tone turns cold and commanding, making it clear that either Frank sits down or gets a bench warrant slapped on him immediately. That's when Frank tries to act brave, accusing the judge of threatening him. Oakley, without missing a beat, fires back. "Absolutely, I'm threatening you." It's pure dominance. You can see Frank realizing he's way out of his depth, yet his ego won't let him back down. The judge's no-nonsense energy is the kind that instantly drains all the pseudo-legal confidence out of these self-proclaimed free men.
Hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today,
You have a jurisdictional argument you want to make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple
no?
why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or-
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty,
What
and
is it?
it's not common law.
Which
It's
one is-
statutory.
Okay, so it's statutory, that is what, civil?
No.
So what is it? For the
My-
record.
Comes the predictable constitutional cross-examination that every sovereign citizen thinks makes them sound brilliant. Frank starts asking whether the judge swore an oath to the Constitution, as if he's uncovered some grand conspiracy. Oakley coolly clarifies that yes, he follows the Constitution, but not in the fantasy way Frank imagines. Frank tries to twist that answer into some declaration of victory, but Oakley cuts through his performance like a buzzsaw. This isn't a debate club, it's a courtroom. When Oakley says, "Get your ass in the chair," it's not a suggestion, it's law being enforced in real time. The entire moment becomes a masterclass in how to handle courtroom nonsense. Firm, clear, and without a hint of patience for delusion.
Is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I injure
are bringing the
the state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm first saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
This part is where the comedy really peaks. The judge calmly asks Frank whether he'll represent himself or let the attorney speak for him. But instead of a simple yes or no, Frank launches into a ramble about presenting himself and not being the person named on the document. It's textbook sov-sit gibberish. You can see the judge trying, for a brief second, to maintain composure. But his patience wears thinner than courtroom carpet. Eventually, he pins Frank down. So that's a no. You don't want him to represent you. Frank proudly declares he doesn't need an attorney, proving once again that ignorance and arrogance make a dangerous combination. Every word out of his mouth is another nail in his own coffin.
Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a
I
question.
object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
Now we reach the infamous jurisdiction argument, the crown jewel of sovereign citizen delusion. Frank demands to know what jurisdiction the court operates under, throwing around words like admiralty and common law as if they're magical escape codes. Oakley, unamused, explains, slowly and clearly, that this is a state statutory court under Michigan law. But Frank won't stop. He keeps pushing the nonsense, insisting the court must be one or the other. The judge finally cuts through with brutal simplicity. You can appeal my ruling. And that's the brilliance of Oakley. He doesn't debate fantasy. He enforces reality. Frank's confusion only grows as his pseudo-legal dictionary collapses in front of him.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
a probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This
says,
is the probable cause hearing.
it says,
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing, Mr.
It's
Michaud.
still, on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
At this point, the hearing turns into an educational video on why you should never represent yourself when you believe TikTok law advice. Frank tries to lecture the judge about injured parties and sworn statements, as if courtroom procedure runs on YouTube theories. Oakley, barely containing his irritation, explains that the people of Michigan are the injured party. It's like watching a teacher explain addition to a student who insists numbers are fake. The more Frank talks, the deeper the hole he digs. And when he starts demanding affidavits and questioning the very foundation of criminal law, it's clear he's drowning in his own ignorance while everyone else just wants the hearing to move forward.
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, in circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, you want to have an exam today?
Well, I wanted to address some, I served the
When Frank refuses to stop talking, Oakley finally hits the red line. His voice hardens, his tone sharpens, and he drops the verbal hammer. Sit down or I'll hold you in contempt. Frank, in classic sov-sit fashion, claims it's another threat. The judge doesn't flinch. He warns him there'll be plenty more if he keeps interrupting. It's a power move that leaves no doubt about who runs the courtroom. You can almost feel the collective relief from the prosecutor's table. This isn't just law in action. It's courtroom theater at its finest, with Judge Oakley starring as the immovable object against a man who's convinced he's unstoppable. Spoiler, he's not.
In this 25 years, I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so,
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great, then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean,
prove
hold on. It should mean something
Can
because,
you prove it? Please prove it.
can I prove what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Eventually, Frank crosses the line one too many times. Oakley slaps him with a $100 contempt fine on the spot. You can see the disbelief on Frank's face. He genuinely doesn't understand how his "I object" routine just cost him real money. When asked if he understands, Frank tries to act clever by saying he doesn't. Oakley's response is pure gold. "You still owe me $100. It's one of those rare courtroom moments that perfectly captures the clash between fantasy and authority. The judge doesn't argue, doesn't debate, he just enforces. And with that one fine, Oakley reminds everyone watching that words don't beat law, no matter how passionately you shout.
Mr. Michaud,
you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or
I
no?
object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days.
Even after being fined, Frank's delusion doesn't stop. The prosecutor calmly begins introducing evidence, and Frank immediately objects again and again, without any valid reason. He starts ranting about probable cause hearings and different dates, trying to prove the paperwork itself is part of some conspiracy. Oakley, once again, dismantles him with logic. A preliminary exam is a probable cause hearing, but Frank can't process that. His confusion becomes almost comical as he argues against basic court terminology. The judge tries one last time to reason but eventually gives up. There's no logic where delusion reigns.